Big shout out to Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there. How about that?
Good afternoon, ma'am. State your full name. Thank you, Ms. Hart. This is on case 2405663, People State of Michigan versus Heather Marie Hart, also known as Heather Hart. It's for the people.
Jennifer Douglas for the people, P72748.
Thank you.
Jessica Schreiber on behalf of Ms. Hart, who is formal reading, understands her constitutional rights and stands to it.
Thank you. Court waived formal reading and her plea of not guilty. Ms. Hart, the court scheduling 2 court dates. You must attend both of them. Probable cause conference via Zoom on April 18th. That's Thursday, 8:30, 36th District Court Judge Aaliyah Sabri. You have a right to a preliminary examination in person following Wednesday, April 24th, in person, 8:30, 36th District Court Judge Aaliyah Sabri. April 18th, April 24th. Understood, Ms. Hart? Do you understand those court date and times you must attend, Ms. Hart?
Yes. Yes.
Not guilty, please enter it on your behalf as to bond from the people. Thank you.
Your Honor, on Ms. Hart, the people are going to ask for a bond of $100,000, 10% cash or surety for the following reasons. Your Honor, we have concern about the safety of the complaining witness. Here, the complaining witness is only 15 years old and recently turned 15 years old. The allegation being that Ms. Hart alleged to shoot him and his dog if his dog managed to make it to the other side of the fence. Here, I know there's a dispute between what the child and the other person with him say happened and what Ms. Hart says happened. But we do note that in the report that there was another individual who was present, and that person provided information that would seem to contradict Ms. Hart's statements about whether she approached the fence or not. Both the child and the other person with them indicate that they saw a firearm. Ms. Hart did tell police she had a firearm, although she stated that she had only threatened to shoot the dog. She hadn't threatened to shoot the child. But we do have, at the very least, Ms. Hart putting herself in the backyard, having possession of that weapon. And when that weapon was turned over, it was in fact loaded, Your Honor. And this is a situation where it just seems like a normal everyday occurrence where when you have neighbors who have adjoining yards, sometimes their dogs bark at each other, Your Honor, and don't necessarily get along. And so for there to be any threat of shooting, it seems unnecessary and also dangerous, especially if one of the people being threatened is a child. Your Honor, given that situation, that it does appear that both parties have dogs, I don't see how it's possible for this to just be a situation with a personal bond and an order of no contact. The dogs are going to be in the backyard. This is
what if I tethered her? What if I tethered her to a location away from the defendant or the complaining witness?
Your Honor, if that happened, then that would address all of our concerns.
That's what I thought. So you'd be fine with that in a personal bond?
Yes, Your Honor.
Thank you. Response?
Your Honor, she has no prior criminal history, not on probation or parole, nothing that I'm aware of. She's an employee of the 47th District Court. She's a lifelong resident with 2 kids, lives with her daughter, did do college. These are allegations. So respectfully asking the court to consider a personal bond without the tether, and she understands the no contact.
Thank you. This is a very serious assaultive allegation against a minor child. It's alleged that you pointed a pistol at the complaining witness and threatened to shoot the child and the dog if they get over here. It's also further alleged no shots were fired, no injuries observed. The APA's indicated that the weapon was recovered with a loaded, and according to investigators' report, with a loaded magazine and one live round in the chamber. So that the court has concerns, as stated by APA, that if I were to allow you to remain at the residence next to this child, that you alleged to have pointed a loaded or a pistol with that was found to be loaded with a loaded magazine, one in the chamber, threatening to shoot that child and the dog, that this is a situation that's not going to be easily resolved because according to the court, because as stated by the APA, that there's going to be continued probably barking of the two dogs that apparently caused this incident. And so the court finds that if given you have no case history, no criminal convictions, you do have ties to the community. However, if I were to release you with no monitorization, I have concerns. And the allegation is you pointed a loaded pistol at a child and threatened to shoot the child and their dog. And so for those reasons, a bond will be set at, as recommended by people, $50,000 personal bond. Ms. Hart, during this bond, there is no use of any alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapons, no weapons. You will be fit with the GPS tether prior to being released. That will have no time restrictions, but it is going to monitor your location. And you are not to go anywhere near and during this bond. So you're going to have to be tethered at a place other than the Dakota address. No contact with the complaining witness, Mr. Harris, and that's no contact of any kind. No contact orally, in writing, through a third person at his place of residency, employment, or through any forms of social media. You'd have no contact with the complaining witness or his address, which is apparently a neighbor of yours. So during this bond, you're to be tethered to another location. Do you have any questions, Ms. Hart, regarding your court date or bond conditions? One moment, counsel, Ms. Scheib or APA, they are neighbors. Is that correct? Because I had a one-off address, but I have different streets indicated in the investigator's report. So
They're back-to-back neighbors. Their yards adjoin in the back.
I appreciate that. So no contact. You're gonna have to be tethered to another location, Ms. Hart. Ms. Scheib or APA, any questions further? Or Ms. Hart, any questions regarding court date or bond conditions, Ms. Hart?
What if I can remove the dog from the location? And then that won't cause any conflict? Can I do that?
Should have been done, in my opinion, prior to this allegation being taken place. My concern. Go ahead.
I never knew that there were neighbors there. It looks like a squatter's house. I've never seen those dogs in my life.
Yes, ma'am, that is correct, Your Honor. We do see that in the report as well. There was no indication that anybody was even living there.
Oh, apparently.
Okay, that's not a concern. Even if they were squatters, I don't feel that you shouldn't pull a gun and threaten to shoot a child. Regardless of these are just allegations, Ms. Hart. I didn't say you did. These are just allegations. I'm just letting you know the reason that I'm asking, or I'm ordering you to be at another location. These are serious allegations that it's just an allegation, or just allegations, but it's allegations that are concerning, that you allegedly pointed a loaded weapon with one in the chamber, live rounds and magazine at a child and threatened to shoot him and his animal. Those are the concerns I have. So to alleviate those concerns in lieu of a cash bond as recommended by the people, I want you tethered to another location, and I would feel comfortable regarding the safety of that child as well as the public. Anything further, Ms. Hart or counsel?
Nothing from the people, Your Honor.
Nothing further, Stacey.
Magistrate.
Yes.
What do I do with my child who has to go to school every day? I don't have any family nearby. The closest family member I have is 300 miles away. What do I do with my child in my situation during these allegations?
Your child can come with you to wherever you go. I have no conditions with your child, and there's no restrictions on the time on the tether. There's no restrictions that you can drive to and from. So you can take your child wherever they need to go, and there's no time restrictions on your tether. So it's your child. That's up to you. But I'm not putting any restrictions on it.
She has school in for.
Understood. She needs, I'm not saying, she needs to keep going to school. I'm not prohibiting her at all from going to school. She needs to stay in school.
Your Honor, it's not possible for my client to stay in her house when those people allegedly, the complaining witnesses, don't even live there and could be squatters, so she could stay in her house and not
Well-
have contact. We see squatters get in front of us
Well,
all the time.
who's saying they're squatters? No, wait, 1 second, APA Douglas. Has that been adjudicated by the court council that they have been determined squatters and in illegal
Well,
possession of the home?
In
I'm just
the
asking that
report,
question.
Your-
Has that been determined by, these are all allegations. My question is, have they been determined in order to be removed by any court?
So, not that I know of, but they didn't even know
Okay.
that anybody lived there, and then we can see
That
that
doesn't
in the
mean that they're
report.
squatters.
So,
All right, well, that
So
has
Your
to be
Honor-
adjudicated by a court.
understood, but we've seen situations where sometimes people live in a family flat or separate doors, and the no contact is there, but they don't have to stay somewhere else. So they don't even live on the same block. They live, allegedly, if this property and whoever lives there or doesn't live there is a backyard. So if my client doesn't have to have any contact, there's no reason to have contact in any way. So if the court wants to put the tether, fine, but did she at least stay in her home, Your Honor?
This,
She has
I said no, the allegations, counsel, is that she pointed a loaded gun with a one in the chamber allegation and a loaded magazine at a child. Not only pointed the gun at the child, but threatened to shoot the child and their dog. And that's what they still lived in the same proximity. So I do not feel comfortable allowing her to go back to the same location where she just alleged to kill or shoot a child and their dog. So no, I'm not
Thank you.
allowing her to go back to the location for those reasons. I'm not going to put a money bond as asked by the people, but I do have concerns. These are serious allegations.
Thank you, Your Honor.
You're welcome. You're welcome. Good luck, Ms. Hart, unless you have any other questions. Good afternoon, ma'am. State your full name, please.
Janetta J. Shaw.
Thank you. Ms. Shaw, your case 240566636, People State of Michigan, was Janetta Shaw, appearance for the people.
Emily Ragnar, for the people, Your Honor.
Thank you. APA Ragnar, good afternoon.
Good afternoon.
Jessica Sharp on behalf of Ms. Shaw, who is formal reading understands her constitutional rights and stands for you.
Thank you, Ms. Shaw. Good afternoon to you too. Court waive formal reading and I plead not guilty. Ms. Shaw, the court scheduling 2 court dates. You must attend both. Probable cause conference via Zoom Thursday, April 18th, 36th District Court, 8:30 a.m. Judge Jefferson. You have a right to a preliminary examination in person the following Thursday, April 25th, 8:30, 36th District Court, Judge Jefferson. April 18th, April 25th. Understood? Those 2 court date and times you must attend, Ms. Shaw.
You said April 10th?
No. April the 18th. Listen close, I'll tell you again. And the 25th. They're both on a Thursday at 8:30. Understood?
Yes.
Okay, not guilty, please enter on your behalf as the bond from the people.
Now, people are asking for $50,000 cash and surety bond for this defendant. If she's able to post bond, we're asking for GPS tether with house arrest. This incident occurred just a few days ago when the victim went over to a location over in the city of Detroit to help a friend move. While he was there, this defendant came out of the house and got into an argument with the victim. The defendant then went back into the house, came out with a gun, waving a gun around, fired 2 shots in the air, and subsequently shot the victim in his leg, in his thigh. Police arrived, they had to put a tourniquet on his leg, and he was transported to the hospital. Now, the victim's wife had pulled up to try to get the victim to go over and help her put together a baby's bed. This defendant said point blank, tell your wife that basically you were sleeping together, and that's when she went in and got the gun. So there's a witness there, the victim's wife. There's another witness there that came, that was in the house. The victim did say at the hospital that he was wrestling with her at the gun, and it went off and shot him. We have somebody also said that the aunt of the defendant stated that she heard 3 or 4 gunshots. And then also situation was obviously very assaultive.
I have a couple of questions, APA, if you could help me out, please. One, do you know if Ms. Shaw was on probation for the FA or assault with a dangerous weapon conviction in 23?
I was just going to mention that in 10/23/23, she pled guilty to assault with a dangerous weapon. She had 75 days in jail. She has 2 years probation. So she is on probation now, Your Honor, for that assaultive matter. So we
Okay, one more question.
Yes.
Can you provide any information about the allegation that she has ATF indicated she had a felony warrant for a firearms weapon offense at the time of this offense?
No, I didn't think that was her, Your Honor. I was just going to get to that.
I apologize. You're correct. Yep, that was the complaint. Yep, thank you. I apologize. That was the complaining witness.
Right, the victim had that.
Yep.
So, correct.
Okay, thank you.
Thank you,
Any
Your Honor.
response, Ms. Shad?
So, Your Honor, if we look at what she's being charged with, other than the reckless, not including the reckless discharge, then it would all be non-assaultive. And then, when we go to count 5, and it is careless discharge causing injury or death, and we go into the report, it looks like a lot going on with a lot of people, but the final thing I see is that it said that the complaining witness states that he stated he went to point the gun into the ground, but while doing so, he was shot. So it appears that they were maybe, I don't want to make assumptions, and these are all allegations, but the point is, I don't think that, I think the gun was accidentally shot because these two were, wrestling over this or whatever might have happened here. I know that she'll have her day in court, but other than that charge, everything is non-assaultive, and that charge is more reckless than any intent or anything like that. So respectfully asking the court to consider a high personal bond, absolutely no contact with the complaining witness, absolutely no weapons. She is employed at Wendy's. She has 3 kids. She's a lifelong resident. She lives with her mother. If the court is not inclined to do a personal without the tether, then respectfully asking the court to allow her to go to work and work only.
Her work hours.
Ma'am, what are your work days and work hours? Please be specific.
I work any day between 10 a.m. and 1 a.m. It's a restaurant, so sometimes I work mornings and afternoons, and sometimes I go in the afternoon and work till 1 in the morning.
So can you please give us those 2 shifts, separate shifts, from what time to what time they would be?
Okay, so far I've been working from 10 to 7 p.m. or 3 to 10 or 5 p.m. to 1.
Okay, thank you. Thank you, Ms. Shad. I appreciate that. Ms. Shaw, you have a bunch of serious allegations. Very concerned about count 5, which is an assaultive allegation. Also noted, I have concerns that you're on probation for assault of conviction, a felonious assault conviction at the time you according to the APA, the time you picked up these allegations, where it's alleged by another witness that you were observed shooting the gun in the air twice. Then you were observed pointing the gun at this witness and in Mr. McGee's direction and firing another shot, striking that individual in the leg. So I find there to be a high likelihood of conviction given the witness's testimony. There was an incident or allegation or somebody was shot, apparently, according to this. And I've read the investigator's report. You did make certain statements which lean towards the likelihood of conviction. And it stated very concerning that you were on probation for an assault of conviction, assault with a dangerous weapon, where you apparently did jail time up front and then probation and have these allegations just months later after being released, apparently. And in order to set an unaffordable cash bond, the court must find by clear and convincing evidence you are a danger to the complaining witness, to the public at whole, or a flight risk. Here, the court finds by clear and convincing evidence, given that you're on probation for a felonious assault, felony conviction, and now we have allegations that you fired a gun in the air twice in the city of Detroit, and then alleged proceeded to fire another shot in the direction of a complaining witness and striking that individual in the leg. The court finds you by clear and convincing evidence to be a danger to the public, and therefore setting an unaffordable cash bond is recommended by the people at $50,000 cash. During this bond, there is no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any dangerous weapon. No weapons. You're not, upon release, if you're able to be released, you must tell your probation officer of this case within 24 hours. If you're able to post bond prior to being released, you'll be fit with the GPS tether, and that will place you under a curfew of 2 a.m. to 9 a.m. During those hours, you are to go to your home and remain there till told otherwise, not to leave for any reason. And during this bond, you're to have absolutely no contact with Anthony Lord McGee II. And you'd have absolutely no contact with any complaining witnesses, including Miss Shaw.
No.
And no contact means no contact of any kind. And that's Jeanette Shaw. No contact orally and writing through a third party.
Sorry. Go
I
ahead.
apologize. No, I apologize. Not Miss Shaw. No contact with the other witnesses, Miss Franklin and Miss London. I apologize. No contact is no contact with any complaining witnesses of any kind, orally and writing through a third party at their place of residency or through any forms of social media. No contact with Mr. Lord II or any complaining witnesses during this bond. Ms. Shaw, do you have any questions regarding your court dates or your bond conditions, ma'am?
No.
People or defense?
Nothing further, Your Honor.
Your Honor, I got the GPS tether and work only, but what was the bond amount? I'm sorry.
And I'm going to say unaffordable. It's 50,000 cash is recommended by the people, and that's
Okay.
unaffordable, counsel.
Yes, Your Honor, that's what I'm asking.
Ms. Shaw,
Yes.
you're going to receive an unaffordable bond redetermination hearing 2 days from today in front of Chief Judge McConico. If you're unable to post that bond, you'll see the Chief Judge on Thursday, April the 11th at 9 a.m. via Zoom, and bond will be re-argued at that point. You'll have a defense attorney present. Understood?
Yes.
Good luck, Ms. Shaw.
Thank you, Your Honor.
You're welcome.